I'm way more serious than what this guy just told you. My name is Heather L. Weigler because I'm a lawyer, and we like to use our middle initials. We are pretentious fucking people. And I'm here today as your comedy lawyer, however, to tell you why you should never, ever talk to the cops. I want to start with some disclaimers and other things lawyers super like. First, I'm a lawyer, but I'm not your lawyer. Nothing I'm saying today should be construed as me giving you legal advice. These are just interesting ideas you heard from your drunk friend in a bar. Secondly, I speak only for myself. You heard I have a very fancy job. I'm a senior assistant attorney general at the Oregon Department of Justice. But I am absolutely sure that the Department of Justice wants nothing to do with me, anything I want to say, or frankly, you all today. They don't want anything to do with you. Last but not least, I ripped this off. This is all based on the research of Professor James Duane. And if you want to know more real things, go read this book. You have the right to remain innocent. Now, next. This is where we're going to start. The Fifth Amendment to the United States Constitution. It's one sentence with a lot of words. The words we care about today are that no person shall be compelled in any criminal case to be a witness against himself, which, right, sexist language, that sucks. We should have a constitutional convention and fix that. But that's not going to happen. That's just like put a pin in that for when that happens. So why do you have this right to remain silent? Well, back when the founding parents were thinking of how should we design our criminal justice system, they looked at what was happening in England and said, fuck that, we don't want to do that. That's the inquisitorial method of truth-seeking, where the person who was deciding whether you were guilty could just ask you, and then if you didn't answer, they could force you to answer. This is one of the ways they did that. It's called Catherine's wheel or the wheel. It's used to break your bones. So instead, they came up with the prosecutorial system of truth-seeking, whereby a prosecutor bears the burden of proving beyond a reasonable doubt that a criminal defendant committed the crime, and there's a neutral arbitrator and a jury of your peers. Obviously, a lot better, right? For a lot of reasons. First and foremost, way more comfortable seating. Secondly, we now have electricity, so we don't need GIMPs. No longer necessary. And last but not least, law enforcement officials can no longer wear their robes and hoods to work. They have to save that for their off time. Hashtag not all cops, hashtag but most cops. So, to understand why I'm telling you this, you have to go with three premises. The first is that our legal system is broken. It is arguably the best in the world, right? But it's also racist. It is sexist. It exploits and disadvantages the poor and other vulnerable populations. It's better than the wheel, but it's a hot mess. Secondly, cops are human beings, as are everybody else who participates in the criminal justice system. They have imperfect knowledge. They come with biases and prejudice that are both explicit and implicit. I'm feeling like the drinks are affecting my enunciation, so sorry. Where was I? Oh, yes, and cops also have confirmation bias, which means that they interpret new evidence in a way that supports their already existing beliefs. They also have imperfect memories. They'll misremember things in a way that supports what they think, and they'll forget the things that doesn't support what they think. And those are the good cops, guys. By the way, they look the same as the bad cops, in case you're wondering. The bad cops will say that they smelled unburnt marijuana wrapped in a plastic bag, in a film canister, under your boob, in your bra, under a tank top, under a sweater, under a big old jacket. They did not smell that marijuana. They will just lie to you. Last. You were supposed to laugh at that, but you didn't. It's okay. I'll keep going. Last is that the odds are against criminal suspects in our system. If you are charged with a crime, you have over a 90% chance of your case ending in a plea bargain. Of the less than 10% of the people charged with the crime that actually go to trial, over 90% of them are convicted on one or more of the offenses of which they're charged. So if you are already charged with the crime, you are screwed. You might be thinking to yourself, but I'm an average law-abiding citizen. I've done nothing wrong. You don't know what you've done. We suffer in this country from the plague of overcriminalization. The Congressional Research Service has said there are so many crimes in the Code of Federal Regulations and the United States Code that they just stop trying to count. And they are the math nerds of law. They've given up counting. They like counting. That should give you some idea of how many federal crimes there are. And then on top of that, you have state law. There's lots of crimes there too, or county law or city law. So you don't really know what you're up to at any given point. One civil rights analyst, there you go, has said that average Americans engaged in normal commerce commit up to 3 felonies a day. Google it, I'm not lying. Next, the laws are poorly written. Lawmakers are not that smart, and they write laws in a way that sweep up a lot of conduct they don't intend to prohibit. Consider for a moment the case of Carol Ann Bond. Poor Carol Ann's best friend got knocked up by her husband. Who would not be pissed, right? So Carol Ann worked at a university. She had access to some chemicals that could cause like minor skin irritation, right? And she doused that bitch's mailbox with some of those chemicals. Bitch got a thumb burn, she rinsed it off with water and was fine. Carol Ann, though, was charged with tampering with the U.S. mails, which is something you shouldn't do. But she was also charged with the crime of violating the Chemical Weapons Convention. That is a law that was intended to prohibit the use of mustard gas, right? So Carol Ann was eventually vindicated by the Supreme Court after 11 years of litigation and many, many thousands of dollars that you don't have. Don't be like Carol Ann. Last but not least, even if you're innocent people go to jail all the time too. Look at these two guys. They were innocent. They were charged with the crime. Luckily for them, they knew the great attorney Vincent Gambino, also known as Jerry Callow. But you don't know Vincent Gambino. Next. So, this seems really aggressive. Woo, it seems really aggressive, doesn't it? Because it is. When interacting with the police in an encounter that you did not propose or request, the first thing to remember is that cops lie. Right, this person knows. And I don't mean to say that to disparage law enforcement officers. They're doing a great job. And that is their job, to lie to you. They will lie about what crime they are investigating. They will lie about whether you're a suspect. They will lie about what evidence they have against you. They will lie that they're on your side. They will tell you that it's not that big of a deal if the guy you stabbed was being a dick. They will lie about anything they need to lie about to get you to talk. They will also make you physically uncomfortable. One study of false confessions found that the average length of interrogation in those confessions was 16 hours. You can't stand 16 hours of the cops berating you. You think you can, but you can't. Trust me. Also, the innocent people are the most easily influenced by these tactics because they wrongly think that the truth will come out and justice will prevail. It won't. The other people who are easily influenced by police lies are vulnerable populations. In that same study of false confessions, 38% of the people who made a false confession were juveniles, and almost 70% had some sort of mental impairment, addiction, or mental illness, something like that, that made them particularly susceptible. See, this is serious. You should also understand that talking can't help you. Because anything you say can and will be used against you in a court of law. Sorry, I've heard that 1,000 times in TV shows, as have all of you. But what you might not know is nothing that you say can be used for you. And that is because of the hearsay rule, which is, this is going to be hard. Hold on a second. lawyers know what I'm talking about. Hearsay means you can't offer as evidence an out-of-court statement made for the truth of the matter asserted. Where are my lawyer applause? I mean, come on. What that means is that if you say some shit, what will happen is that in court, the prosecutor will call the cop and say, did the defendant say all this stuff that made them sound guilty? And the cop will say, yeah, they did. They're totes guilty. And then your lawyer will say, but didn't they say all this stuff that made them sound innocent? And the prosecutor will say, objection. And the court will say, sustained. And the jury will never hear about that stuff. So nothing that you talk about can help you. Also, truthful statements can be used to convict you. I'm going to have to read a little bit of my card here. So, sorry, everybody. You might say something that you thought was true at the time that you said it and it turns out to be false. And the prosecutor will say, look, that defendant is a liar. And the jury will say, well, the prosecutor and the cops don't have any reason to lie, but that defendant sure does. And then they'll believe the cops and the prosecutor. Also, you might say something that corroborates what an eyewitness has said, or that provides a basis for a dubious expert to opine that you are guilty for some reason. There are some statistics there. Numbers are hard. I'm skipping them. Next. But I prevail upon you to not plead the fifth. Why? Because it's this motherfucker. This smug piece of shit was Supreme Court Justice Antonin Scalia. The good news about him is he's dead. Woo! It's kind of tempered, though, because his replacement also might be a POS. I don't know. I mean, he is, but, like, how bad is it going to be? We're going to see. He's done some yes, some no. Anyway, the bad news about Antonin Scalia, there's a lot of bad news, actually, but one of the things is that he screwed up the Fifth Amendment before he died. How did he do that? He wrote an opinion in this case called United States v. Marshall, in which he said, when a defendant refuses to answer a question about whether he did it, that's suggestive that he might have done it. And then that dissent was used in a case called Texas versus Salinas, in which the Supreme Court said it was okay for an officer to go up to Mr. Salinas out of custody and say, so, would the shotgun shells in your shotgun match the shotgun shells at the scene of the crime? Well, Mr. Salinas very wisely refused not to answer that question by just remaining silent. And the Supreme Court said, well, he wasn't arrested. So it's okay for the prosecutor to say that's suggestive evidence of guilt and for the jury to find so. Boo, right? Like lots of Supreme Court justices rolled over in their graves when that happens. But what the practical effect of it is that a criminal suspect now has an affirmative duty to assert their constitutional rights, which is pretty scary, everybody. Don't talk to the cops. So what should you do? You should not be Homer Simpson. Your goal is to end the interrogation and say nothing, but you can't stay mute, as I just explained. Salinas will not work in your favor. And also invoking the Fifth Amendment, if you're inartful about it, might not work in your favor. There was one case in the Eighth Circuit where the prosecutor commented to the jury that the defendant's statement that I better stop talking or I might incriminate myself was evidence of guilt, and the Eighth Circuit said, yeah, that's not a clear error. It's okay. Send that person to jail. Also, in some states, you might have a presumption against you in any civil action if you assert your Fifth Amendment constitutional rights. So you should be really careful about it. What should you do instead? The Sixth Amendment, right? And the thing that you should care most about is that in all criminal prosecutions, the accused shall have the right to have the assistance of counsel for his, again, sexist language, right? Like we should have a constitutional convention just for that. Yeah, who is the only person that applauds? You're my best friend now. So how do you ask for a lawyer? You cannot be equivocal. Oh, I wasn't supposed to do that. Let's make that go away. Okay. This is where the drunken part of the discourse comes in. Woo! So, So, you cannot be equivocal, which means not that there can be no doubt in the average person's mind, but that no doubt in a cop's mind. So, here are examples of statements that courts have said, those are equivocal. We're not really sure if they were asking for a lawyer. Maybe I should talk to a lawyer. I can have a lawyer? I think I want a lawyer. What time can I call my lawyer? I can't afford a lawyer, but can I have one? Can I call my lawyer? Do you think I need a lawyer? Why are those statements bad? They use hedge words. Don't use those. They're bad. They also ask questions of the cops. The cops are not there to help you, everybody. Don't ask them questions. They're not going to give you the right answer. And lastly, all those people were trying to make themselves sound polite, but I think that they should look at that cross stitch and rethink that. So what is the thing that you should say if you are in a police encounter that you did not propose or request? You should say, I want a lawyer. One more time for the people in the back. There are only 4 words. You don't need to be rude. All you need to say is, I want a lawyer. Thank you very much. I'm Heather Weigler.